Have you thought about backing out of a real estate deal? Maybe you signed a contract a long time ago, or maybe it was a little bit recent and you just need to get out of the situation because unfortunately circumstances have changed. It's happening a lot right now in today's market, just with valuations all over the place, and it's kind of not a good time to own real estate. It's not as good as it was before anyway. So there could be situations where you want to get out, but let's talk about some financial implications, some legal implications, and perhaps even some alternative options that you can pick if you need to change your mind and get out of a real estate deal. Stay tuned.
Look, I get it. The Toronto real estate market is confusing. Whether you're a new or experienced investor or just looking for a home to raise your family in, join us at Broadview Table Talks as you sit around the table with my friends and talk about the real estate and the ever-changing market in Toronto.
It's a rough time right now with, as mentioned before, like let's just say you bought a pre-construction property 4 years ago and you're coming up for closing and circumstances have changed. Maybe you have a different job, you lost a job, or even the valuations have dropped. That happened to a lot of us that bought pre-construction condos a little while back. Or maybe you just bought a resale condo, even commercial property, and you were depending on the sale of your property to buy the next property, but that sale didn't happen, or it fell through another reason of somebody else and not of your own, or you couldn't get financing. That's a very common scenario that's happening right now in today's market. It's an uncertain market, and I guess that's why having good professionals on your side, like good real estate agents, good lawyers, good bankers, in case something goes wrong. Like in a smooth transaction, everything's great, no problem, simple transaction. But in a difficult situation, when this happens, you need some good advice. First things first, I have to get through some legal disclaimers. This video is just general advice. It's not really even advice tailored for you specifically because your situation might be different. Consult your lawyer, consult your mortgage professional, consult your real estate agent as well too. Talk to them about your scenario. If you don't have one and you're in a situation, give me a call. Maybe I'll be able to walk you through it. Or if you're thinking of buying or transacting in real estate, it's really easy. Just click the link below. There's a little calendar invite where we can book a mutual time. It's just a 15-minute video call. Ideally, you can do a phone call as well too. I like to get to know a little bit more about your situation before I give you any specific advice. That being said, it's happening a lot more today in today's market. And the reason why is because valuations are all over the place. Like condo market's dropping a little bit in terms of valuation. Freehold is on track to increase 5 to 10%. That's what the forecasts say. It's still kind of early on in the year. The activity hasn't really been that prominent as it was before in the past January, February's. It's a little bit of a wild market right now. No one really knows where the values are going to go. Some people are saying it's going to go down. Some people are going to say it's going to go up. It really depends on what kind of information you're getting. Let's just say you bought a real estate contract. Maybe it's a pre-construction condo that you bought 4 or 5 years ago and you're up for closing now, but the valuations have dropped significantly that you can't find any way to close no matter what you're doing. Beg, borrowing, and stealing from anybody, it just doesn't work. Or maybe you bought a resale property and you're expecting or counting on the person who bought your place to buy the next place. All that could happen, and let's just say they called up and said, listen, I'm not going to close. There's a lot of ramifications to not closing. It could happen to the seller of the place that you bought as well too. They might have plans for that money depending on what their scenario is. It's kind of a weird time right now. It might be a situation where if you bought a pre-construction condo 4 or 5 years ago and you're just finally coming up for closing now and the appraisal values are, call it 100 grand short, 200 grand short. Like say you bought something for 800,000 and it's only appraising for 700,000 and there's no way you can come up with an extra 100,000. It's actually even more than that. The gap could be even bigger. Or let's say you bought a resale property counting on someone else to close on your place, but there's no way they can get financing. So that means you can't have the funds to close on the next place. It's just a large domino effect, and the seller of the place that you bought, they potentially are waiting for your money as well to close on something else. So it just goes up the chain. It gets really nasty. These are legally binding contracts that you're signing. If you entered into a purchase and sale agreement, you put down a deposit and it goes into a trust account, which is governed by the Trust and Real Estate Services Act through the Real Estate Council of Ontario, which actually is legislation, it's law. You can't simply just say, I'm going to walk away from my deposits. In this example, let's just say you bought a $2 million property and you put $100,000 down, which is typical for a deposit, about 5%. You can't just say, I'm going to walk away from 100,000 and call it a day. It doesn't work that way. What would happen is that if you failed to close on that purchase, let's just say they turn around and they sell it now for $1.8 million. They put it back on the market, they sell it. There's potentially some carrying costs that you have, some taxes, some interest, some legal fees that the seller will have to pay. You have to pay all that. So you're gonna pay the difference of when you failed to close at the $2 million mark and it sold for $1.8 million. There's a $200,000 gap there, plus the carrying costs, plus the maintenance fees, plus taxes, plus lawyer fees, all that stuff. It really could add up, and ultimately it is the failed purchaser's responsibility to pay that. Litigation is an expensive process. It doesn't mean that you'll get the money right away. The money will be held in a trust account for a long, like the deposit that original purchaser, the $100,000 you put down, that's going to be held in a trust account for quite a bit of time, several months until you get the court case, and then it has a hearing and all and so forth. So depending on the scenario, it might not be advantageous for the seller to actually come sue you. It might be better just to arrange for a mutual agreement to potentially walk away from that deposit, just forfeit the $100,000 that you put down. I wouldn't expect the seller to agree to that because it's not in their benefit at the end of the day. It just depends on the scenario that you're going through. It's too general to just kind of give you advice right now on what to do. In the case of a builder deal where you bought something from pre-construction, the builder has presumably deep pockets, right? I mean, if they're building more than one unit and assuming it's a condo or even a subdivision of homes, I would think they're well capitalized and they have more money than you anyway. For most people, most purchasers, they have no advantage to let you out of the deal and release the deal. They're going to sell it and recoup that money eventually anyway. So it's a very small chance that they're going to let you out of the deal. The only issue that I see for developers is that if the majority of people are not able to close because of whatever reason, then the condo doesn't get formed if it's a condo. If it's freehold, it's a different story. Maybe they might have some solutions for you there, right? You can negotiate with the builder for forfeiting the deposit, letting you out of the deal, which is called a mutual release. You're like releasing each other from further liability. Or it could be that, potentially even the builder, if they're able to, if they have enough deep pockets to be able to, if the profit they would have gotten right away, maybe they give it back to you in forms of a vendor take-back mortgage, which is basically a loan to you through their books. So maybe that might be a solution as well too. It just depends on the builder, depends on your scenario, depends on their scenario. Again, it might be easy to just mutually release the parties and just move on. I just can't see much of a scenario where that would be beneficial to the seller or the person not in breach of the agreement. Some alternatives that you can go through is potentially assigning the deal. You could sell it to ideally a family member that's willing to help you out, that wants to help you out, that cares for your well-being. It might be a right fit for them to actually purchase or acquire an asset, real estate asset right now anyway. So they might be able to help you out, or they could partner with you and either they loan you money or use their name for borrowing power. Like I know it really sucks if you're in a scenario like this to be able to have to beg somebody for money, and I get it, but if you're really pushed against the wall and your financial implications of being sued, they're going to go after you because they potentially go after your other assets, like your primary home, for example, if you bought an investment property, or just anything like that. Like that could be a major issue, and partnering with somebody that might bail you out of a situation, like a family member or a loved one or a friend or whatever, that might help, right? Or you could potentially, if it's a good enough deal, assign it to somebody else to be able to buy it. Now, I get when you buy pre-construction condos, they don't allow you to advertise the sale on MLS. And the reason why you do that is because two reasons, really. Mainly, you're competing with their inventory that they have left over that they want to sell, so it just kind of sets the price. But the main reason, you're going to be setting a bar because you're in distress, right? At the end of the day, that's probably why you want to sell it. And if you're going to be in distress, you're going to sell it at a lower price, which just basically sets the bar for appraisal values for all the other purchasers that purchased. An independent appraiser is going to come in there to make sure that the asset's secured for the lending for the bank. They're going to see your sale and it's going to set a lower bar, and then now all of a sudden the developer is at the risk of majority of people not closing because appraisal values are really set low. So they do not want you to advertise on MLS. If your back's pushed up against the wall and you can't close on it anyway, then that might be a strategy. I mean, I haven't really seen that actually happen where they're not going to let you out of a deal, but then you breach the contract. Like potentially you can get sued for even more damages. Like I wouldn't play that game if I were you. That's typically why they don't let you advertise assignments on the MLS. If you work with a good broker and you have enough compelling deal for a purchaser to buy, because again, from the eyes of another purchaser looking for an assignment, looking for a good deal, they're out for blood. Yeah, at the end of the day, you could say that they are looking for a good deal, and they can get a good deal by buying something resale. Like, why do they have to buy something at an inflated price? Well, not inflated, I would say it's a higher than market value price of what you can get something on the resale market for. Or if the unit above you or below you, maybe they're assigning it and just jumping ship and willing to walk away from the deposit. So in other words, if you assign it to somebody in the public, it's got to be a good deal. It's got to be compelling enough. There's a case that I was looking up really quickly. It was a house out in Stouffville, $2.25 million house. The buyers actually forfeited $30,000 of their original deposit, but then it went to court and they got sued for $470,000. It's a big, expensive lesson to make. They wanted to back out of the deal and they didn't want to complete the deal. And the reason why they backed out of that $2.25 million purchase is because they couldn't sell their own home. Being caught in that situation really sucks. It's a risky proposition. So again, they lost $30,000 deposit. They got ordered to pay $470,000 in damages. And the court based this on the difference between original and the eventual sales price plus carrying costs and other damages as well too. It's really important to meet your contractual obligations. It's important to fulfill your agreement. There was another scenario where there was a builder picture just recently that just happened. It was a pre-construction freehold house in the suburbs. They couldn't get an appraiser in there last minute to get access to it because it was under construction. They were willing to comply, so they're left scrambling for money to close. So they finally found some private money to close in the place, but then they closed 6 minutes late after the deadline of 5 p.m. They eventually sued the purchaser for $100,000, and not sued for it, they demanded $100,000 to allow them to close. Fearing being sued, the buyers actually did pay the $100,000, thinking they were going to sue the developer back for unjust enrichment or whatever it was. And it actually went to court. They lost. The courts determined that, yeah, time is of the essence. They had to meet the 5 o'clock deadline, and it's not their fault that they didn't meet it, right? It's not the builder's fault. So they actually lost that case, and the builder walked away with another $100,000. Now, presumably that was the market value did appreciate quite a bit in that area. Maybe they bought it too low and the developer's covering some of the costs, because why would they do that for a risk of reputation? But it actually did happen. Guys, time is of the essence of the deals. Like, that's some learning lessons you can have. An agreement to purchase a property is a contractual obligation. Make sure you adhere to it. It's not just that easy to back out. But there might be scenarios where you could potentially negotiate a release or sell it to somebody else, or ask for a lifeline from a family member or friend to help you bail yourself out and get out of the situation. So hopefully that helped. And there might be some questions that I found online that might help you out as well too, that you might be thinking. What are some of the most common reasons that people back out of a deal? Well, it could be most likely that they couldn't sell their own home to buy the next place. Or in the case of pre-construction, maybe the appraisal values fell short. I mean, those are the two most common scenarios that I see. What happens to my deposits if I back out? You potentially could get sued for more than just your deposit. But if you sign a mutual release, the name implies you're mutually releasing each other from what? Well, from future obligations, future lawsuits. Can't claim any more after that. Once you sign the mutual release, both parties agree. Or it could be just some sort of agreement where it says you can walk away from the agreement, but it doesn't limit our ability to sue you afterwards. Like, there's some fancy lawyer language for that. I've seen that happen as well too. Can I back out if I find issues during the inspection? Let's say you already purchased the place, you're firm, you waived all your conditions, it's not contingent anymore, and you're contractually obligated to purchase the place. But then you go back to the property, you go check it out, and then you find a big issue, like you found mold behind the walls, or there's a giant damage to the floor that was hidden by a carpet. Well, there's two terms that are known in the legal world to describe these scenarios: a patent defect and a latent defect. Patent defect are visible issues, things you could have reasonably seen through your own inspection. Maybe it was something like a hole in the wall, or like a crack on the foundation or something like that, and you just didn't see it, right? Like, that's your own fault. There's something called caveat emptor in Ontario law, which basically means that it's buyer beware, right? So it's your own fault you didn't see it. It's right there in plain sight. It's your own fault. A latent defect, on the other hand, is a non-visible defect. So it could be mold behind the walls that you didn't see because there's no signs of it coming through and it just got worse. Maybe it might be a leak that you've only noticed because it was a rainy day and you wouldn't have noticed that otherwise. Well, unfortunately, you can't claim after that either, unless you know that the seller purposely hid it. Like, for example, if there was mold and they just spray painted or painted it, not spray painted, they painted it, and then all of a sudden it bubbled through afterwards. And like, it has to be something that they chose not to disclose and something that they chose to misrepresent. Ultimately, that's fraud, and you can sue them after the fact, but the issue has to be material enough to not close, to say that the seller breached the contract. So you can't just pick apart any kind of deal just to find a reason to back out of the deal. Like, that, it doesn't work that way. You have to close and then sue them after the fact. Otherwise, the buyer will be in breach, you'll be in breach. How can you avoid penalties by backing out of a pre-construction deal? Well, it's not very likely unless you can get the seller or the developer or the company that built the project to let you out of the deal. So generally, situations like this I've seen in the past is when the values have actually appreciated much higher than what you originally bought it for. Then they'd be happy to take the unit back to sell it at a higher profit and make that difference. And potentially you forfeited your deposits in between that. Or it could be a scenario where, it's a sob story, like something really did bad happen to your life and, they're letting you out of mercy. It's very rare that that happens. I've only seen it happen once in my life, and I'm not going to go into the details of that because it is private information. I don't want the person who got let out of the deal or the developer to come after me for releasing that information. So there could be scenarios where that could be the case, or again, you could assign it to somebody else, maybe at a potential discount where you potentially even lost your deposit or even more than your deposit. And what should you do if the seller doesn't agree to a mutual release? Again, that's situation specific, but it's the art of the deal. Like Donald Trump, you just find their weakness and use it against them. It's a stupid story, but I was like really early on in my career, 20 years ago, when I bought my first property. I ended up selling it. So I bought it for $200,000 at the time. I think I sold it for $370,000. But when I signed it back, I wanted $375,000 for it, right? Problem is, I wrote that in the email, but in the paperwork, I didn't change the numbers and I still signed everything. They could have come after me for the difference. They wanted to buy it for $370,000. I didn't notice till after everything was done. It was the holidays, it was busy at the time. So my lawyer, who I've worked with for 20 years, he's been genius. He found out they were non-residents. So then he said that they'd have to put a deposit if they were to sue me for the court. And going through that process is expensive, and the litigation process is just insane, especially if you're non-resident. So I played chicken with them and I played head-to-head, and I said, you know what, listen, it's gonna go through an expensive and time continuous litigation process. So why don't we just renegotiate the deal? And that's actually what happened. So we did split the difference, which is a learning lesson, but yeah, that could actually happen in the case. And you have some scenarios where you could get out of a mutual release deal, right? Like, it wasn't a mutual release, like we did end up completing the deal, but I could have pushed for it and gotten out of the deal that way, maybe. Okay, so I rambled long enough. I hope that helped you a little bit. I know it's a tough situation. If you're watching this video, it's probably a tough situation you're in. So reach out to me if you have any questions, or if you're looking to buy, sell, trade, whatever in real estate, just give me a shout as well too. Thanks for watching.
Add it up. Thanks for sticking out to the very end. I hope you got some value out of this. Do me a favor, please press like and subscribe, but more than anything, leave me some feedback so we know what to produce for you going forward. Thanks again.